Good evening, everyone. I'm Nicholas Pope. I'm a lawyer working on the various court challenges that are going on. And I just want to share with you an update on the 3 court challenges that we have in the process right now. And one of them was just filed this afternoon, actually. And I'll tell you about that first. So, Kathleen, whose behalf we filed this judicial review, she's been living with treatment-resistant depression for the past 35 years, since she was 15 years old. She's tried everything. She's tried all sorts of medications, therapies, treatments. She's even tried electroconvulsive therapy multiple times when her condition was so bad, and it's caused her permanent memory loss. So she's done all this. And she managed to find out about psilocybin-assisted psychotherapy. She found a doctor, and the doctor assessed her and determined that this was a reasonable medical choice for her, especially after these last 35 years where she's not been able to pursue the career she'd like to pursue, hasn't been able to have children as she would have liked. And then this doctor had to fill out the SAP Form A, 18 pages long, citing 81 peer-reviewed articles, an intensive clinical rationale, all the medications that this patient has ever taken. This has to be submitted to Health Canada for a bureaucrat to review, after this specialist has already assessed the patient and determined that this is the treatment that's necessary for them. So this doctor spent hours filling out this form when this doctor could have been treating other patients. And in the healthcare crisis that we're in right now, that makes no sense. So after all of this 18-page form gets submitted and goes into Health Canada, and that was submitted on Friday of last week. Now, back about a year ago in January of 2022, when the amendments were brought in to allow access to the Special Access Program, one of the promises was that these will be replied to within 1 to 2 working days, because I just brought a court case on behalf of Nathan Kroljack, where it was 100 days for a Section 56 exemption, no response. We brought the court case, we went all the way to 2 days before our hearing. By that point, it was about 220 days. 2 days before the hearing, they grant his exemption and avoid a judge having some fairly stern words to say about Health Canada. So that's what the promise of the Special Access Program was, 1 to 2 days. It's now Wednesday, it's been 5 days. And I didn't mention this, but Kathleen is at a fairly elevated risk of suicide. She filled out the SQVR, the Suicide Behaviors Questionnaire, revised as part of her application, and indicated that she was well above the threshold for an elevated risk of suicide. And so she's sitting there at home tonight waiting on this decision after her doctor has already assessed her, waiting on a bureaucrat to pick up the pile, take a look at it, and see what should happen to her. And so today we filed an application in federal court asking for the court to compel an approval from the government. We're also asking for a declaration that her Section 7 charter rights were violated. This is not the first time this has happened. Back in December, another patient, terminal cancer, he had a number of months left to live. Applied, was fully assessed, this big long form filled out. 10 days later, no response. We brought a judicial review application. A day later, it was approved. A week ago, another patient, suicidal, treatment-resistant depression. 9 days went by. Brought a judicial review application. A day and a half later, it was approved. And so this 1 to 2 working days doesn't seem to be 1 to 2 working days from the time that you apply. It seems to be 1 to 2 working days from the time that you hire a lawyer to bring a court case and sue the government. And is that the system that we want to live with? Where it's sort of this pay-to-play system. You can hire a lawyer, well then we'll get on it in 1 to 2 days. But if you can't, good luck. So that's case number 1. Case number 2. As Anthony mentioned, he's one of these 96 healthcare practitioners who requested training and has been denied it. Now, this is the first case probably that's going to hit the courts. I've requisitioned a hearing, so we should have an actual hearing date at sometime in the next couple of weeks or months. And I'm very much looking forward to hearing what the judge says about this, because one of the issues here is that the minister denied the request for training because they said healthcare practitioners can provide this therapy without personal experience. Like, it's possible to do that. But then when we got the documents underlying the decision, there were these consults with all the experts. And it says right there on the page in the government documents, all the experts we consulted strongly indicated that personal experience is required to safely guide patients through this therapy. And so the difference in words is very striking. Yes, nobody can test. You can guide someone in psilocybin-assisted psychotherapy without proper training. But can you guide someone in safe psilocybin-assisted psychotherapy without training? That's not what the government experts say. That's not what any of the literature says. It all goes opposite to it. So I look forward to a judge seeing this, seeing the piece of paper that says what the government experts said, and then the rationale provided. It's like if you said, if you need an appendectomy, you need your appendix taken out. Well, I know where an appendix is. It's about here. If you hand me a scalpel, I can start cutting, and I can probably remove your appendix. But can I do it safely? No. People have the right to safe medical treatment, not just to get their appendix butchered out. And it's the same for psilocybin-assisted psychotherapy. Case number 3 is the larger charter challenge, Hartle et al., and that's the one that Janice is one of the co-plaintiffs on. It's seeking to overturn the whole system, strike it all down, so that the government has to do something to make a better system, because the system is broken. You have Kathleen having to put in all her medical history, tell the bureaucrats about this, wait, when a doctor has already decided that this is a reasonable choice for her. And you have these healthcare practitioners unable to get training. There's many other problems that I won't go into today, but the whole system needs to get overturned. And the good thing is that there's a solution, and it's not that hard in the world of solutions on Parliament Hill. There's a lot of solutions to things that are very difficult. You have to pass legislation in the House, you have to get consensus among multiple parties. But the solution here is regulations. That doesn't need a vote in the House. It can be passed by the minister unilaterally. And the work's already been done for the ministers. A year and a half ago, Therasil did a large amount of work, brought on experts in this field, and built regulations, draft regulations, based upon the medical cannabis regulations, and presented them to the minister. All that needs to be done is for these regulations to be adopted, and all 3 of these court cases will go away, and we'll have a proper system that gives people proper access and stops people from dying unnecessarily, from waiting for treatment, or from getting treatment on the black market, as they have to do. And so I'll stop now, but I'll leave you again with Kathleen, that tonight, right now, she's sitting in her home with an elevated risk of suicide, waiting to see what will happen, waiting to see if a bureaucrat will maybe tomorrow morning decide to pick up her file off the desk and approve the thing that a specialist has already spent a lot of time looking through, doing the research, and assessing her for that she should have. Hopefully, she'll get approved tomorrow. Maybe she will, maybe she won't, but that's not the way it should work. There's an easy fix, it's the regulations. Thank you.